Boston legal.
116,000 people strolled the hallways of the Museum of Modern Art in New York City over the course of 47 days to drink in the beauty and simplicity of Matisse's Le Bateau. Clouds, water, a sailboat. They all looked right at it. And not one of those 116,000 people recognized that it was hanging there upside down. This must be the right way to look at it. But it wasn't. Now here, the district attorney would be delighted if not one of you questioned his version of the crime.
Kind of an interesting intro to his closing argument, right? He's kind of using an analogy here to say maybe there's a different way of looking at things, even though it might appear to be the right way of looking at things. He's trying to lay that foundation for, my guess, is a reasonable doubt argument, right? He wants to show there's reasonable doubt that his client committed a crime so that he can get that acquittal and get his client free.
As jurors, is to consider whether there is another way to look at this. Would you want a woman deprived of her future husband to spend the rest of her life in prison if there was even the slightest chance that she may be innocent? And there is that chance. The prosecution could not establish beyond all reasonable doubt that nobody else entered that room. They admit.
So his entire speech, I'm guessing, is going to be about reasonable doubt, that the prosecution hasn't proven beyond a reasonable doubt that this lady, presumably, didn't kill the fiance, right? And so his entire speech is pointing in that direction. The guy brings in the note, hands it to him. There's going to be some theatrics there, maybe with some new witness or something that may or may not be coming in. He's doing all of this to get the jury to think, well, maybe she didn't kill him. Maybe we should let her go.
The crime scene was contaminated. We know this man had jilted 3 previous fiancées.
Well, heck, that's reason right there, right? 3 ex-fiancés, any one of them could have killed him. Who doesn't want to kill their ex-fiancé? I don't know.
Possible one of them showed up. Or maybe somebody completely different. We've heard testimony that there were a lot of people coming and going that day. Perhaps an individual slipped unnoticed into the room. Perhaps dressed as a delivery person. Amid the hustle and bustle of the corridor, everyone was distracted by their own concerns, as we all are. Maybe a woman, a brunette, like Renata, quite like Renata. And perhaps this woman attacked Javier with his own scissors, which he grabbed from his bag. Or perhaps this woman was someone from Renata's past, and it was Renata she attacked in a jealous rage, and Javier was stabbed in the process. Perhaps Renata was the intended victim.
Objection! He's arguing facts, not in evidence.
There were no witnesses to this crime whatsoever. That's a fact in evidence.
So you hear that a lot in TV shows. It does come up in the real practice of law from time to time. Facts, not in evidence, right? You can't just go spouting off about things that have nothing to do with the case. And so he has a nice response there in terms of there being no witnesses. So that's a fact, and he can just kind of go and take that as far as he can to, again, create those seeds of reasonable doubt, get his client off.
And suppose there was another woman who did this. Well, ladies and gentlemen, there is such a woman. We have found her, and will now produce her. She's willing to walk through that door if the district attorney agrees to show leniency by discussing a plea.
See, this is dangerous, right? So I'm going to go ahead and assume that there is no actual person and there's no one coming through the door. He just made an affirmative statement to the jury saying, hey, we found the person and she's here and she's coming in. If that doesn't turn out to be true, he's lied. So I get he's trying to create that reasonable doubt, but he also at the same time might have just destroyed his own credibility, right? Because he's just intentionally misleading this jury. So I'm not sure how that would shake out, but my best guess is no one's walking through that door.
What?
Can I tell this woman you're amenable to a plea bargain?
Your Honor, there is no such woman.
Then what's the harm in striking a deal?
I'm not going to deal with a mystery woman.
How can you not if you recognize she exists?
I do not. I just...
Have doubt. Reasonable doubt.
Objection. I object to counsel's entire summation.
Mr. Shore?
Never mind. Luckily for you, we've been able to compel this woman to come forward, even in the absence of such a deal. Clarence, please bring her in.
Cue the music. Is she coming in? Is she not coming in? My vote is she's not coming in. And it's all a bunch of nonsense. Jury's watching, suspense building, music's up.
Okay, I was kidding. She's not coming through the door, but she could have.
Your Honor, this is a trick I saw in a Judd Nelson movie. They also used it on Matlock.
I love that Judd Nelson movie, by the way. It's from the
an
hip.
old and venerable illusion that has been used to great effect, dating all the way back to the turn of the century. And apparently, it's still being used today to great amusement by others such as Perry and Judd and
Matlock.
and me.
And who doesn't love Matlock? Those of you that know who that is or what that is. So, just asking all the viewers, are you sold on this kind of approach? Did you have doubts, that there was a person coming in, not coming in? Is it enough? I'm not really sure with the way he sells it because he made some affirmative statements there. And I think when you're dishonest to a jury, it's really hard for them to find you credible. So that's just my quick 2 cents.
But regardless of the skill with which it is executed, the success of the trick, like any great trick, relies most of all on audience participation, on their predisposition to the possibility of it working, the possibility that it could be true. That possibility is why you, all of you, looked at the door. The district attorney looked at the door. Everyone looked at the door with curiosity and expectation and belief, the belief that there is another woman.
What do you guys think about the defendant and the look on her face? She looks guilty as hell, doesn't she? It doesn't even look like she is convinced. And the question is, and I didn't notice this because I don't think the camera was in that direction, did she look at the door? Because if she didn't, that's a problem. So I'm not sure if she did or if she didn't. But if she didn't, I'd find her guilty.
That belief, that is reasonable doubt. If you looked at the door, that's reasonable doubt.
Yeah, she looks guilty to me. So pretty cool scene there, right? And obviously it's a criminal trial. We haven't seen all the facts, but in this country, to be convicted of a felony, you have to show guilt beyond a reasonable doubt. So good defense attorneys, to get acquittals, they try to create that reasonable doubt, which is what he did here. And he did it pretty masterfully. Of course, it's all Hollywooded up and everything like that, but definitely a cool way to go. And let us know what you think about that.